Welcome to the Indian Gaming Association's The New Normal webcast. My name is Lisa Johnson. I'm the conference manager for the Indian Gaming Trade Show and Convention. I'd like to share a few housekeeping tips before we get started. Everyone is muted by default except for our speakers. If you have any questions during the presentation, please type them into the chat box and they'll be brought up at the end. Now, without further ado, I'd like to introduce Victor Rocha, conference chairman of the Indian Gaming Association.
Good morning, Lisa. Good morning, everyone. I'm Victor Rocha, conference chairman of the Indian Gaming Association. Welcome to New Normal, your go-to source for discussions on the gaming industry and key issues facing Native American tribes. I'm Victor Rocha, conference chairman of the Indian Gaming Association. My co-host Jason Giles is going to be a little late. He'll be joining us about halfway through, I believe. He had some very important meetings. He had to climb into the belly of the beast. Hopefully, we'll be able to get him back. Today, we're joined by an old friend of mine, Dan Wallach. Welcome, Dan, one of the nation's leading experts on gaming and sports betting law. Where he's here to discuss the rapid rise of prediction markets and what their expansion means for state regulators, tribal governments, and of course, the future of gambling in the United States. Welcome, Dan. This is the first time joining us, isn't it?
That's right. There should have been a prediction market on Dan Wallach being off of his
Wow.
normal.
Listen, when you and I started working on the same side of this thing a year ago, nobody thought that we would, but people don't know, we've known each other, we've had dinner, we've have been friends for a long time. And listen, just because you scrap doesn't mean you don't like people. And as you know, I scrap with a lot of different people, but welcome, Dan. I really appreciate you joining us.
Oh, it's an honor to be
This
on.
is Yeah, this is a big issue. First of all, even before we can talk about too big to fail, let's talk about the announcement this morning by Kalshi and Tariq Mansour. Tell us about it, my friend.
The National Hockey League is now, I guess, signed on as a sponsor or some kind of, partnership with Kalshi and then on the Squawk Box. I think that's CNBC or MSNBC. I forget which network. Tariq Mansour, your friend, teased the possibility of other sports leagues signing similar partnerships, which does come as a little bit of a surprise to me because it was only 3-4 months ago that the NBA and Major League Baseball wrote comment letters in connection with that CFTC roundtable in which they sounded the alarm bell over the lack of sports-related integrity safeguards in the state-centric system. And in the tribal system, you have state statutes and state laws that require information sharing, cooperation, and integrity monitoring. None of that exists with regard to sports on the CFTC. They've never passed rules. So I'm kind of curious to see how and why MLB, the NFL, and Major League Baseball may have come around on this point because the situation sure hasn't changed over the last 4 months.
I didn't read the deal. Are they offering them more money, or is this just more about fan and sports engagement, fan engagement and stuff like that? Or is this, the new shiny thing?
Well, the National Hockey League was one of the first to really stand behind some of these partnerships with legal sports betting because Gary Bettman, the NHL commissioner, has been on record as asserting that the National Hockey League doesn't have any integrity issues.
Right.
Okay? Not like baseball, football, or basketball. So from his vantage point, the issues that Major League Baseball and the NBA raised aren't at the same level of severity as in hockey, where there really haven't been any match fixing scandals, and the league was the first one, I think, to stand behind state-sponsored sports betting several years ago. And I think Gary Bettman is all about increasing revenue streams, ancillary revenues, and propping up franchise valuations so that the expansion fees keep going up, and when owners sell their teams, they can get more money. Integrity be damned. So it doesn't surprise me that the NHL was the first to sign on, but I question their choice of partner because in watching how Kalshi has conducted itself over the last year and a half, they've been an extremely reckless company in getting over their skis and putting out public comments and marketing materials that tout that they're legal sports betting in all 50 states. And now they're in France, they're doing props and parlays. I would say that if you're a conservative organization, sports federation that is concerned about the potential for the perception from fans that everything's not on the level, they've just aligned themselves. I think among all the designated contract markets, they're probably the riskiest partner to take on, given how aggressive they've been in pushing the envelope way beyond what they originally argued.
Yeah, someone mentioned it was Kalshi and Polymarket, but it reminds me of one of my favorite entertaining things over this weekend was the fact when Dustin was talking about that Tariq and them were talking about how addictive their product is, and then all of a sudden you had these corporate statements saying, "Oh no, we are all about responsible gaming," and yet they're talking about how addictive it is. You know
Well,
what I mean?
you got
And I think Freud would say, we know what Freud would say. It's gambling, you know.
it is, they've said it's gambling. And more importantly, the distinction between what Kalshi is offering in Polymarket versus what the tribes and the states are offering is like the age limit. They're trading with 18 years of age and older can buy and sell event contracts tied to sporting events. You can't do that in the vast majority of state or tribal governments. There's a baseline of 21 years of age or over. So the 18 to 21 is probably the most at-risk segment for compulsive and problem gambling. And then you tack on top of that the absence of any responsible gambling or RG protocols or gambling type consumer protections that are identifying problem gamblers. It talk about the Wild West. This is the Wild East, centralized in New York City and Washington, D.C., without any sports-related protections, without any responsible gambling safeguards. What could possibly go wrong here? And reputationally, for the leagues, for the OSB operators, that can come home to roost very quickly.
Well, I think the big question is, so when is everybody else going to jump in the pool? Is it a matter of time? Is that what we're looking at?
I would say the message that I've been delivering on social media is we've only had a couple of court rulings so far, three or four, only four, Nevada, New Jersey, Maryland, and then the second Nevada decision with crypto.com. The decisions are trending in favor of the states. The courts are finally addressing the issue of congressional intent and analyzing how implausible it would have been for Congress to have banned sports betting through the Wire Act and PASPA, and then at the same time to tacitly allow it through an obscure, opaque commodities exchange without expressing clearly and manifestly that that was the purpose of the federal law. So they begin from a very difficult legal argument in overcoming the strong presumption against presumption against preemption, which attaches to fields traditionally regulated by state governments such as gambling. So the courts are finally analyzing that argument and honing in on it. And as a result, the Maryland decision and the Nevada crypto decision have turned on the touchstone inquiry of congressional intent. And that's not going to change going forward. So I would say to the online sports betting companies and to others that want to dip their toe in the water, we're four decisions in, it's trending the wrong way, and there will be at least 6 to 8 more decisions between now and the end of the year. And if you want to take the temperature, I think the right time to do it would be on January 1st, when we have the result of the tribal case tomorrow in San Francisco on a motion for preliminary injunction. We have the swing state of Massachusetts, in which Massachusetts is the first state to directly sue Kalshi. And if the state or the Commonwealth succeeds in getting that lawsuit transferred back to state court, it's a slam dunk victory for Massachusetts, which means that they could get geofencing around the entire Commonwealth of Massachusetts if a couple of court rulings over the next few weeks go in the state's favor. So I would just caution, just assess the state of the courts in 2 months. And I think you'll find the trend line pointing decidedly in favor of the states and the tribes, at least in most of those cases. And you'd be foolish. You'd be absolutely foolish in dealing with tribal, governments and in dealing with state regulators to offer sports prediction markets in the face of potentially many adverse court rulings. And I think it is a slam dunk. There is an issue of standing somebody raised in the comments section. The states have a particularly strong legal argument, but the tribes have low-hanging fruit of the IGRA violation, provided they can demonstrate that they have standing to bring those challenges. And I believe that they do. So the message here is preaching patience and cautious behavior and assessing on January 1st. And I think it's going to be a very volatile and risky move for any operator that wants to dip their toes into the prediction markets water. You got to wait.
Yeah, and I think that's what we see because, a lot of the people that are or the companies that are moving are, Polymarket and Kalshi are moving at breakneck speeds. FanDuel and DraftKings are freaking out. They're on the sidelines getting prepared to jump in. Everybody else is waiting in. But the bigger question really here is, states' rights. You know what I mean? I think it all boils down to states' rights. And you look at the tribes are, you mentioned yesterday about the tribal amicus briefs yesterday that were filed yesterday in Massachusetts. Tell us a little bit about that.
A call out to the four tribal, it's like the tribal lawyer dream team, right? You have
Right.
Joseph Webster, Brian Newland, Scott Kroll, and Mike Honig. Three out of
Right.
four of those individuals I've probably been on the opposite side of and arguing some of my IGRA theories in the West Flagler case. But I've come to respect everything that they've accomplished. They, especially Joe and Scott, they were instrumental in persuading the DC Circuit U.S. Court of Appeals and the federal government to allow for tribal state compacts, which included, I guess, references and jurisdictional transfers that would permit iGaming and online sports betting. That was a momentous accomplishment. And it kind of surprised me, but I've gained a lot of respect for Joe's abilities. Well, they've teamed up. The same group has teamed up in filing amicus briefs all around the country in all of these Kalshi, Robinhood, crypto.com versus state cases. And they've blanketed the country. And I've got to tell you, their briefs, their amicus curiae briefs are better than even the state's briefs, better than any other stakeholders' briefs. That not only have they called attention to the implied repeal of IGRA, but they've argued the Commodity Exchange Act and the CFTC related legal issues better than anybody else. Not one word is wasted. And if I could identify a turning point here, it would have been the Maryland case, where that was the first time a court ruled in favor of the state, and that was helped immeasurably by the tribal amicus brief, which Joe Webster and company filed in Maryland, even though there were no tribes in that state. Their vantage point, I guess their MO is a victory is a victory. We're going to participate in every single one of these lawsuits and try to turn the tide and rack up wins. And until the tribes joined the battle, Kalshi was kicking the state's asses. Kalshi had on its side Milbank. Five sat behind those lawyers. It's like a murderer's row, and I've used that expression continuously. It's like a murderer's row of high-powered litigators with CFTC and U.S. Supreme Court experience. And on the other side of the aisle, the states are insourcing their legal work to the state AG's offices. It's a mismatch. And that's why, and no disrespect to any state attorney generals, but if New Jersey was smart enough, hi, Jason, if New Jersey had the prescience and the foresight to hire Ted Olson a decade ago to bring legal sports betting to the state of New Jersey and to the rest of the country, why wouldn't you bring in the same kind of firms to save the relevancy of state authorized sports betting? It's the opposite side, or it's the flip side of the same coin. And I think the states got caught off guard, flat-footed, and their initial briefing on the issue I considered to be not particularly strong. And as a consequence, Milbank kicked their asses in New Jersey and Nevada, racked up two quick wins, and then the pendulum started to turn or swing based on the tribes getting involved. And now Nevada hiring one of the preeminent U.S. Supreme Court lawyers in the country, Nicole Saharsky, who's a partner at Mayer Brown, one of the largest firms operating in the U.S., to, I think, now level the playing field and have sort of equal firepower on both sides of the V. Previously, it was like the New York Yankees against the Tidewater Tides. And any state AG's office attorney that gets mad at what I said, I didn't say that they would have to be replaced. It's just you're stronger in tandem than
Right.
you are by yourself. And state attorney general's offices typically litigate issues of state law. These instead here are nuanced issues of federal law involving the federal constitution, the supremacy clause, conflict preemption, field preemption, express preemption, implied preemption. These are very sophisticated issues of federal law that are very well suited to the more sophisticated law firms to handle in tandem with the AG's offices. And once Nevada hired Mayor Brown and Joe Webster, Scott Crowell, and Mike Honig, as well as Brian, got involved on the tribal side, it became a pivot point, at least in my opinion.
Is that why we're seeing that a change of opinion about swaps in Nevada? Because I see everybody like screaming about that. Was that the source of that?
I think so. When you have Mayor Brown arguing that case on a motion, it was Crypto.com's motion for a preliminary injunction that tracked Kalshi's motion for preliminary injunction. It was the same case, but instead of being argued only by the AG's office, now you had Mayor Brown and you had all these tribal amicus briefs, and then on top of that, the same judge certainly has had a more well-steeped experience with these issues because he's now been assigned to these cases for at least 6 months, whereas when he ruled for Kalshi preliminarily, he had only been on the case for a couple of weeks. The issues were not adequately briefed, and even his ruling in favor of Kalshi did not address the issue of whether the sports event contracts could be classified as swaps under the Commodity Exchange Act, which is one of the, I don't think it's the most important issue, but it is a very important issue. And he didn't deal with that issue until the tribes and Mayor Brown started raising it in the Crypto.com case. And his ruling was not necessarily inconsistent with the earlier ruling. He denied Crypto's motion because their event contracts around sporting events are based on outcomes of sporting events, whereas the definition of a swap under the CEA is based on the occurrence or non-occurrence of an event. The event is the Kentucky Derby. So who wins or loses the Kentucky Derby is the outcome of the event. It's not the occurrence of the event. Maybe he's splitting hairs, but he backed up his analysis by going through the legislative history of the statute, the lack of explicit, clear and manifest language in the Commodity Exchange Act that demonstrated the intent of supplanting state sports gambling laws. So he went through the same analysis as the Maryland court, but then for good measure, he concluded that outcomes of sporting events cannot be treated as swaps. Otherwise, everything is a swap. The outcome of whether Jason makes the podcast in time, yes or no, that could be a swap because the adverse consequences potentially, and that's the definition of a swap, whether there are potential adverse, potential commercial, financial, or economic consequences. You being late for the podcast maybe brings our ratings down, and advertisers ask for give backs. So if you analyze,
but he wore a suit.
Right. So
well, Daniel, let me jump right in, and I apologize for being
by the
late.
way, Jason, my condolences on the passing of Chairman Stevens. I wanted to express that to Victor at the beginning of the podcast, but you weren't here, and I wanted to wait.
No, thank you, Daniel. And
I didn't know him personally, but he obviously a legend in tribal gaming, and more importantly, a beloved family man, and that is truly tragic. And I just want to express how sorry I am for the passing of that great man.
And I don't want to thank you, Daniel, for bringing that up, because I want to thank everyone on this podcast. I know there's very many folks on there that reached out and were at the services and or reached out to myself and the offices. So thank you. Your messages are conveyed to the family and the tribe. And, we're moving forward. Like Chairman Stevens said, he's like, there's always more work to do. Let's just keep working. And let me ask you, Daniel, off of what you were just saying, right now, where do you think in Nevada, I've heard there might be some issues over discovery, the discovery process. And then also, I think some of the Third or Fourth Circuit arguments got moved to next year. The appeals, the argument date, which is to say, if you've got issues over discovery, the appeals court argument is now put off till next year.
Mm.
We're running out of time here. NHL signing a deal. You got the CME rumored to be moving quicker towards the prediction markets with FanDuel.
Mm.
This stuff is getting normalized fast.
Yeah. That's why it's imperative that instead of
so is crack. Crack spit across, and with a year it was everywhere, and it was normalized. You know what I mean? And you still had to
Well,
fight that too, and there's
I
still
agree.
curriculars,
Look at the states, as Daniel was alluding to. The states have been fighting war on drugs for a long time, and it's a harsh reality. But like you said, I heard you say they were caught flat-footed on this one. But Daniel, we still go and talk to state gaming regulators. They have no clue what this issue even is. We've talked to state agricultural people. They're like, do you know what the CFTC is up to? They're they're supposed to be doing sports betting now. What do you think about? I just don't know that these court cases are ever going to move fast enough to get a hold of this. And like you said, Daniel, the CEA is kind of wishy-washy in some of this stuff.
Yeah, and they don't need to move quickly enough.
Mhm.
What needs to move quickly are states taking action and suing Kalshi and not outsourcing, or at least depending on the New Jersey, Nevada, Maryland, and
Okay.
Massachusetts cases, because each state individually could prevail over Kalshi and maybe get a preliminary. See, I think there's this misconception that states should wait on the sidelines because this battle will now play out in multiple appellate courts and the Supreme Court will eventually decide the issue. So why should why should we waste the bandwidth and the resources and expenses? But the truth is, states individually can prevail in their cases over Kalshi and avoid either preliminary injunctions against the state or secure preliminary injunctions against Kalshi. Now, there's that oral argument tomorrow in San Francisco on behalf of the 3 California tribes who are seeking that. Massachusetts is the only state that is seeking a preliminary injunction to block Kalshi entirely from the Commonwealth with its sports contracts. If they win those motions, and Kalshi is unsuccessful in getting an emergency stay of that injunction pending appeal, they're out. They're out. Even if the Supreme Court is going to change the landscape 2 years, 3 years hence, at least in the interim period of time, victory, I think, is on a state-by-state basis. And once Kalshi is forced to geofence around 3 tribes or around the Commonwealth of Massachusetts, that will, I think, ignite a barrage of similar lawsuits from other tribes throughout California, other states throughout the country. But the states have to get up off their asses, and I think they're held back, one, by maybe their regulators don't have the jurisdictional authority to bring these lawsuits, but the state attorney general's offices do. And part of the problem, I think, is funding. Good luck wading into an area like this, not having enough expertise, having to hire outside counsel at a cost in the low to mid 7 figures over 3 tiers of federal court review. I think it's imperative on the operators, the licensed operators, and even the tribes in those states to almost work in tandem with their state governments, almost like a private-public partnership, and underwrite the funding of these lawsuits. Because I got to tell you, I think a number of states like Arizona, Illinois, Montana, they've issued cease and desist letters to Kalshi. Michigan and Arizona have warned their licensees that if they get involved with sports event contracts, they may jeopardize their licenses. So those states, in my view, are prime candidates to enter into the litigation arena, but I think they need some help from their licensees if they aren't already planning to bring these lawsuits. And just as Ted Olson and Gibson Dunn were responsible for New Jersey winning the sports betting case 10 years ago, or almost 10 years ago, I think a similar private-public effort using big-name law firms with the cost underwritten by state licensees and maybe even tribes could go a long way to bringing these recalcitrant states off of the sidelines and jumping into the litigation arena. Because I can tell you with respect to Arizona, there is already case law in the Ninth Circuit from the Crypto.com case and potentially from the November 14th ruling in the Nevada Kalshi case that could represent Ninth Circuit case law, which could benefit Arizona, which is also in the Ninth Circuit. So there's an opportunity here for Arizona to jump in, and for only 3, 4, 5 states to be waging this battle when
Right. Well,
39 have legal sports betting is just,
so where, Daniel,
puzzling to me.
I mean, Victor and I have been joking on this podcast since February. Where the heck is Utah? Where, Texas? Those 2 states, like you just said, it would be a clear cut case.
Yeah.
Utah has no gambling whatsoever.
Well,
maybe they're invested in crypto, man.
Yeah, the Texas AG.
The whole state is invested in crypto. That's my theory right now.
They have criminal prohibitions against sports betting, but they don't have a licensing scheme. And the states with the licensing schemes have more incentive to bring suit because they're protecting the regulated market in addition to forestalling, illegal behavior. The states that only are focused on illegal behavior have somewhat less of an incentive to sue. What about Florida? I think the most well-situated stakeholder to bring this kind of lawsuit would be the Seminole Tribe of Florida. They have statewide exclusivity to online sports betting, and the state of Florida gets a 13.5% revenue share based on net win. So for as much as Kalshi and Crypto.com and Robinhood penetrate the Florida market, that not only takes dollars away from the Seminoles, but it takes dollars away from the state under their revenue share agreements with the tribe. So I think there's a real significant incentive, at least within Florida. And if someone is saying, well, DeSantis is not going to want to cross Donald Trump, and I see that Mike Brooks has been our most prolific commenter on the chat room.
I have no idea who he is.
Yeah, I think he's with an entity that is I don't want to mischaracterize it, so I'll let him describe it. But the Seminole Tribe is already in the game. They're one of the amici curiae that have signed on to the Massachusetts amicus brief, which was authored by Joe Webster, Scott Crowell, Mike Honig, and Brian Newland. They're already involved. They're involved through amici as an amici. So if they're involved indirectly in the cases already, they could get involved directly, and it would be a slam dunk victory for them because the tribes have the federal legal argument that they're able to advance under IGRA, as well as the Lanham Act based on falsely advertising that Kalshi is legal sports betting in all 50 states. So the state of Florida could advance the same arguments that Maryland and Nevada have advanced to moderate success so far. And then the tribes, the Seminoles, have a separate federal law argument, and those two together could drive Kalshi out of Florida tomorrow, should they be so inclined to sue, because this all boils down to the issue of congressional intent. And when you look at the legislative history of the Commodity Exchange Act, and the key piece of legislation here is the 2010 Dodd-Frank Act, which amended the Commodity Exchange Act to give the CFTC exclusive jurisdiction over swaps. And swaps are the vehicle that Kalshi, Robinhood, and crypto are arguing is broad enough to include sporting events. So at the time that Dodd-Frank Act was passed, you had PASPA, and you had the Wire Act, which together evinced a strong, vocal federal policy against interstate sports gambling. So against that backdrop, I think you should be cynical and dismissive of any notion that Congress would have secretly, silently, tacitly created an alternative framework without explicitly saying so. And then the Murphy case, Murphy versus NCAA, which led to the overturning of PASPA. If the U.S. Supreme Court had only known in 2017 and 2018 that the federal government was already providing a regulatory framework for sports betting, the leagues would have won that case. The state of New Jersey won simply because PASPA only commandeered the states without providing any federal scheme of regulation or deregulation. So if the argument that Kalshi and Polymarket and crypto and Robinhood are advancing today is true, it was also true as far back as 2010, and it was true throughout the entirety of the PASPA litigation, and nobody, not a soul, raised it, which means it's all a bunch of BS, and it's fabricated, after the fact to justify it, and only through clever lawyering has Kalshi even gotten this far, along with the fact that they don't seek CFTC approval for anything, Victor. They can self-certify any event contract they want, and it goes into effect immediately.
Which is hysterical.
The Trump aspect.
Hysterical that Sarah Slane had a comment today on Twitter about capture. You know what I mean? And we were talking about capture. She said there's an important role for casino regulators, but it is not on federal exchanges. And I think she's a little dyslexic there. I think it should be there's an important role for federal exchanges, but it is not in the casino business. You know what I mean? And I think that's what she meant to say. And she had a thumb slip. You know what I mean? So if you want to talk about capture, we could talk about that all day long with that group. But you know what? You have a CFTC that is is no longer functioning. It's basically a star chamber with one person, you know,
Daniel-
and sorry, Carolyn, if you're out there, you know, so the whole intent is to move fast enough so that you can't, you know, and like you said, so you can't stop it. It's clever lawyering. It's a lawsuits. It's a way to stop it. But you know, a lot of us see through that bullshit. You know what I mean? A lot of us see right through that, and we're not going to stop. You know, we don't stop. We can't stop. I know there's a song in there somewhere, but you know, that's not what we do. You know what I mean? We fight. We have to fight for what's left of our sovereignty and whatever it takes, and that's what we do. Jason,
But Daniel,
I apologize. Go ahead, jump in.
well, Daniel, so when we talk to the different senators, these prediction markets right now are operating, they're untaxed. There's no taxes or fees being collected. They're unregulated. There's no one watching what they're doing. There's no consumer protection. And I encourage everyone to go watch Tariq Mansour's CNBC interview this morning on CNBC.
It's on Daniel's Twitter.
He-
You can watch it there.
The first question had nothing to do with consumer protection, but boy, that was like the top of his talking points. So the first two sentences out of his mouth.
Well, I should have heard him on Friday before Dustin got a hold of him.
Well, you know, they can keep running around saying they're well regulated and the consumer's protected, but it's just not the case. And what we're worried about and what we're also trying to point out is, why should we have to wait for something bad to happen before we start to see the sheen comes off these prediction markets, that they're not really just, the odds on a future event happening. And, this is all just risk, laying off risk and hedging and all those sorts of arguments, because, in the UK, they do have these prediction markets, Daniel, but we've talked to one of the UK regulators who was at the National Gaming Regulators Conference in Nashville this year. And his big thing was, these markets are well regulated over there. They have a whole board that watches what's going on each day. Well, and they will take down bets that are against public policy. They'll call it and say, get them off. We don't have anyone doing that right now. That's how will Zelensky wear a suit? I mean, it's stupid stuff. I mean,
I'm glad you raised that, because the CFTC already has a regulation that expressly prohibits these event contracts. 15 years ago, the CFTC passed Rule 40.11A1, in which they imposed a blanket prohibition on any event contract that involves, relates to, or references gaming or anything similar to gaming or anything that's illegal under state law. They banned this 15 years ago in reliance on the special rule that was enacted as part of the Dodd-Frank Act, which gave the CFTC the power to prohibit contracts as contrary to public policy when they involved any of 6 horrible things like war, assassination, terrorism, dysentery. I'm joking about that, but gaming and activity that's illegal under state or federal law. They created 6 categories where the congressional intent was, these aren't event contracts we want, but we'll delegate to the CFTC the authority to determine whether a particular contract involves or relates to any of these activities, because they have that expertise. And then the CFTC took that congressional intent and codified it in a regulation saying, we're going to impose a categorical ban on all of these contracts. And they've enforced, or they've held to that ban for 15 years, until Donald Trump became the president of the United States, and until Donald Trump Jr. became a strategic advisor to Kalshi and to Polymarket. And 3 days into Donald Trump's presidency, Kalshi began self-certifying event contracts tied to the outcomes of sporting events, even though there was a regulatory ban against those contracts. And in that self-certification, Kalshi represented under oath that sports event contracts would not be in violation of any CFTC regulation, which was false, because there was an existing CFTC regulation which explicitly banned gaming contracts. And this administration and this agency is just choosing not to enforce it. And why do you think that is? Follow the money, follow the relationships. And if anyone else in the United States were president, any other Republican candidate, forget putting aside Democrats, it could have been any other Republican candidate. All of this is happening simply because it's going to benefit the Trump family. And we all know that. And now all the big money on Wall Street, ICE, Citadel, all the powerhouse Wall Street firms, the White House, and now the sports leagues are pulling their weight in favor of this system, all of which was based on it's all predicated on regulatory capture. So when Sarah Slane accuses state governments of not having a level playing field because of regulatory capture, she's placed the onus, or she's ascribed the wrong item to the states. That's actually her company, her industry. Tarek, all of those people are benefiting because the CFTC has been infiltrated and captured by the Trump administration and refuses to enforce that existing rule. And that has come up continuously in these court cases. Hasn't been the main reason why the rulings have gone recently in the state's favor, but some of the judges, I think Judge Gordon and Judge Abelson in the Nevada and Maryland cases, made reference to Rule 40.11A1. So you don't start with that rule, but if there's a regulation on point which says these are not allowed and the CFTC is not enforcing that rule, it does beg the question, why is that happening? And you have to point to the political power base and who wants to see this happen. I'm sorry. I mean, I'm going to get audited tomorrow. I know. That's the truth.
Well, they've gutted the IRS too, so I don't know.
Yeah, I wouldn't worry about that. There's nobody. There's even less people at the IRS than there are at the CFTC.
The CFTC only has one commissioner. The Elon Musk,
a janitor. They have a janitor. I think they have a night watchman.
30% less staff, and they're on a government shutdown right now. All of their employees are basically furloughed, except for 31 people, which is less than the size of the Rhode Island Lottery Commission, which means that the Rhode Island Lottery is a more robust regulator.
This is Idiocracy, the sequel. This is. You know what I mean? We are living in Idiocracy, the movie, and this is the sequel.
I got to say, this guy, Mike Brooks. Mike, you got to give it up. You're on the list.
Calm down, filibuster.
Yeah, you don't have to silence him.
Yeah. Hey, Lisa, could you boot him out? We're done.
No, you can keep him here.
Yeah, he said, she's there not doing anything. But, well, Daniel, I mean, listen, tribes, we're trying to get our tribal gaming commissions, as you said, more involved. And I think that's where our play is heading. And where we are now is getting the tribal gaming commissions to work with their state regulator, if there is one. And if there isn't, work with the state AG and start, going after these guys in IGRA violations. Now, that's something that hasn't been tested yet.
It's too slow. That's too slow of a process. I would emulate what the 3 California tribes are doing. They brought
take it yourself.
Okay. Yeah, I would advise everyone on today's call to watch tomorrow's hearing in San Francisco Federal Court. It's on Zoom, and the 3 tribes have moved for a preliminary injunction to get Calshi to stop offering event contracts on tribal lands. And we'll know by the end of the hearing tomorrow which way the judge may be thinking, unless it's a cold bench. But, ordinarily you can predict the outcome based on the types of questions that are being asked during oral argument. And if the Northern California tribes win that motion, I think that should be a signal for other tribes to don't talk to your regulators, don't talk to the AG. You can just start filing lawsuits just like that. And I'm not sure that the state attorney general's offices have the empowerment or authority to raise IGRA claims. They have the authority to raise state law claims. IGRA can be asserted, I think, by the tribes and by the federal government, maybe the NIGC. I'm not exactly a maven on the administration of tribal gaming law, but if the White House has captured the CFTC, I wouldn't place a whole lot of faith on any of the federal Indian agencies to be completely aligned with the tribes on this issue. It might have to be the tribes alone going this route, or the tribes supporting different states where the tribes are prominent. For example, Arizona should be in this battle. And maybe if the tribes were to assist the state through contributions, towards legal fees, maybe you pass the hat around, get some of the commercial operators to kick in some of the fees, because that'll be the ultimate litmus test for loyalty. Like, I don't expect the OSB operators to start bringing direct lawsuits when they're flirting with prediction markets, but I think their best case scenario is to be market leaders in states incrementally where they have the upper hand. And if they had their druthers, I think they would rather have the prediction market cases go in the state's favor and have everything revert back to the status quo. And then eventually, when California, Texas, Georgia, Minnesota become legal, there'll be significant revenue opportunities. But on the CFTC side, it's going to be like the Wild West. I mean, there's no barrier to entry. You can buy a DCM, you could partner with one of those other acronyms. Everybody and anybody can conceivably be your competitor on the CFTC landscape. Whereas in the tribal gaming and in the state regulated gaming, there's a limit to who or which entities can get licensed. And it's a playing field that I think is more advantageous for these for the commercial operators, which suggests that if they want to see you guys win, if they want to see the states win, I think they should help fund some of these lawsuits so the states can get up off their asses. And Arizona, Missouri, Illinois, and et cetera can get in the game, because Kalshi can fight 3 or 4 states at a time with ease, but you got to put them on their heels with not only 4 states, but maybe 10 states, and then bring offensive motions for preliminary injunction against them and seek affirmative relief to keep them out of those states. To date, only 1 state and 2 tribal cases have pursued that offensive remedy. In every other instance, the states are playing defense and allowing Kalshi to frame the narrative of the lawsuit around the issue of preemption rather than the legality of the contracts. The states need to become more aggressive. They have the better argument by far, but they're losing the ground game.
Okay. Right. Right. Well, yeah, and Justin, we've been talking about this since the very beginning, that the states need to get involved. The tribes can only do so much, and it feels to me that they're slow in waking up to the threat. When the threat is very obvious, the taxation dollars are going to start coming in. You just saw this the last couple of days that in Nebraska, they're talking about the lottery is $10 million short because of gambling expansion. And if you read between the lines of what they were saying, they're talking about offshore, they're talking about sweepstakes, they're talking about the online gaming and stuff like that, but they're talking about offshore stuff too. So the states are starting to wake up to the corrosive effect of this new wave of gambling, be it sweepstakes and now prediction markets, and both of those are fought on different playing fields, as we both know.
Yeah.
That's why the tribes were able to fight so quickly against the sweepstakes in California. And the states did wake up to the fight against sweepstakes, but the prediction market seems to be lulling everyone to sleep like a carbon monoxide poisoning.
The sweepstakes are the easier battle because
I
they're not
agree.
regulated. They're not regulated by anybody. They're obviously illegal under any kind of state law analysis. Proof is in the pudding of 100+ cease and desist orders. They didn't fight one of them. Okay, the prediction markets, on the other hand, I think are just as illegal under state law, but they're protected under a thin veneer of federal regulation and have that statute that they're clinging to, like their lives depend on it, but it's a threadbare justification for federal preemption. So I think you're going up in class now. The sweepstakes operator is pretty easy to vanquish because they give up rather than fight. They only know how to lobby in legislatures. They know that they can't litigate these issues. The prediction markets, on the other hand, they've got all of the major Wall Street firms behind them,
Right.
Milbank, even Gibson, Dunn and Crutcher. Ted Olson's law firm, which represented New Jersey, is now representing Robinhood. So you're fighting the powers that be, Wall Street, the White House, the leagues, and all of the white shoe Wall Street law firms. It's a major uphill battle. And eventually, the states are going to, I think, swing the pendulum even further in their favor by winning in Massachusetts and potentially other states. But you've got to look ahead to the ultimate battleground, which will be Congress. And too much money is invested in this sector for these stakeholders to simply see all of their multi-billion-dollar valuations dissipate overnight when the states and tribes win a couple of court cases. There undoubtedly has to be a plan B. So you got to fight this on two fronts. You got to fight it in the courts, and you've got to peel off Republican, federal lawmakers that might be inclined to fall in behind President Trump. You've got 9 Republican congressmen and congresswomen in California. You've got 1 in Nevada. You've got to peel away those votes and proactively address or deal with the potential or the prospect of Congress placing its thumb on the scales to satisfy the president. And a lot of people think that's impossible with 39 states having already legalized sports betting. But when you have Wall Street, the White House, the NBA, NFL, NHL, Major League Baseball, Citadel, ICE, all these major, financial institutions, Susquehanna, all the money behind the prediction markets, stranger things have happened. And you need to be prepared for that eventuality and not get caught flat-footed like the states did when Kalshi began suing Nevada and Maryland. You need to, because if you win in the courts, the only way they could pull this away from you is if Congress changes the law. If you prevent that from happening in the courts and in Congress, you win. The only thing that the CFTC or the prediction market stakeholders can do is try to push through regulations or rulemaking under agency law, and those can be attacked in the courts as being contrary to congressional intent for many of the same reasons you're arguing why there's not federal preemption right now, that the agency does not have the statutory authority to rewrite the Commodity Exchange Act to include sports gambling contracts when it's clear that Congress did not intend that law to serve that purpose. So you got to play three-dimensional chess here. Get more involved in the courts, but also be concerned about the down the road risk that they're going to place their thumb on the scale in Congress and rip this away from you in perpetuity.
Well, first of all, 2 things I want to say. Like I sat with Daniel and I had this conversation. I started laughing. He goes, they're playing 3D chess. I go, yeah, but they keep eating the pieces. So it's hard to play the game when they're eating the pieces. But also, Daniel, we know a thing or two about the Wild West. That's what I wanted to go back to you. So as Native American tribes, we know a thing about the Wild West, about where this is going. But Jason, here's the big question, at what point, where is the turning point? I think it's our duty. We don't stop fighting. That's not our job to stop fighting. It's not our job to negotiate. That goes to leadership. You know what I mean? And
keep turning Joe Webster loose.
Yeah. Well, listen, listen, everywhere I've been, it's like, don't stop there. I haven't heard anyone say, you guys got to stop. You guys are going to stop the future tribal gaming. For us, it's like, we know the existential fight it is, and it's our job to discuss it here. And Jason, what were you going to say?
Well, I mean, Daniel, it goes back the congressional aspect, and someone asked a question on there about what is going to take Congress to move. I mean, they're mired in this ridiculous shutdown. They can't even pass a budget. And every time we talk to a congressperson and explain this to them, people from farm states, you got to go back and explain it to them again. And there's it goes over their head the first time. Maybe the second time they'll start to realize that. I will say, to your point, Daniel, the senator from Mississippi, she's got the joint letter with Cortez Masto from Nevada, and they asked the CFTC some pointed questions. They're not going to get anything out of them. They're just going to come back with wishy-washy stuff. But that's a start. And we need to peel off some more of those Republican senators, as you said. But that does worry me that, there's not just from the state side, Daniel, this and I don't know if it's an apathy or they just don't understand what this is and how it actually works on the ground and what is going on out there. And our messaging is as much education as anything. And I don't know how to break that logjam. I really think that somebody like a DeSantis would they don't they're willing to go after stuff, and crack down on the Texas AG is notorious for just, hard hitting, prosecution and everything. And those types of folks are just silent on this one, even though that they prefer that their state citizens not be able to gamble. And I still have a hard time wrapping my head around why they're so reticent on this issue. You know, and like you said, what's a turning point, Victor? Again, I hope it's not some major scandal where, you know, a player is betting on himself or a coach is betting on his team. But typically that's what it takes, you know, to get this kind of stuff. Because Daniel, when they talk about consumer protection, and I'm telling you, that was the first two sentences out of Kalshi's mouth this morning. It's laughable, right?
Yeah.
I mean, it's just there's nothing there. There's nothing to prevent a kid from, you know, getting a credit card and signing up.
Well, consider the ethos of the company's outside counsel from Milbank, Josh Spector. He spoke at Nicolgee's this summer, and he said he spoke as a private citizen, but he was there representing Kalshi. And he was completely dismissive and arrogant about responsive gambling concerns. And he said, you know, almost verbatim, that if somebody wants to, you know, lose their shirt, that's on them.
Mm-hmm.
And that was included as a footnote in the tribal amicus brief filed in Massachusetts yesterday. But they're only paying lip service to the responsible gaming issues, because if they really were concerned about that, it would be 21 and over, not 18 and over. They wouldn't advertise as aggressively as they do. They wouldn't be throwing in parlays and props. And as I mentioned on X the other day, their early victories in Nevada and New Jersey were predicated on the storyline being the Masters, the Super Bowl, the Kentucky Derby as sort of the the illustrative event for which there are economic consequences. You can buy that, but now they've gone aggressive and began self-certifying touchdowns within a game, prop bets, parlays, and that's going to open the door, and it already has opened the door to Nevada seeking to dissolve the preliminary injunction that Judge Gordon issued to Kalshi. They're pointing to the fact that it's no longer about the Super Bowl. They're now doing event contracts around, you know, statistics within the game that don't have any potential economic consequences to anyone other than the athlete, maybe hitting his performance bonus incentive clause.
Right.
So their own marketing and their own desire to grow as aggressively as possible, I think, will be their undoing in the federal courts. And I really think this is a state's issue and a tribe's issue. To get federal lawmakers on board right now, it's too long of a process. First, you have to start to hold their feet to the fire in the federal court system, the state court system, start bringing more of these actions against them under IGRA and under state law, and then the momentum will continue to go into the state's favor. And if you get court victory, there's no such thing as prediction markets here to stay. Sarah Slane this morning on LinkedIn was touting the new NHL partnership, and at the bottom of her LinkedIn post, prediction markets are here to stay. Bullshit. If the court shut it down, it's over. And unless Congress intervenes, it's over. You cannot take any of this for granted. If you begin to feel defeatist, or it's out of my hands, or it's bigger than my individual state or my individual tribe, you're playing into a losing attitude. You gotta keep fighting, because you have the better of the legal arguments by far, but apathy will be your biggest opponent.
Well, Daniel, you know what? I guarantee, you know, the tribes are talking in Wisconsin, the tribes are talking in Minnesota, the tribes are talking in New Mexico. Where the tribes are and they have that influence, they are talking to their state reps. They are pushing to get, and in California, to pushing their states to get into this fight. So we understand that it is a states' right issue. And the fact that this amicus brief is resonating, again, and we've said it for in the other prediction markets, we felt that, you know, Kalshi talking to us, their intent was to keep us on the sidelines for as long as possible. But, you know, we didn't buy into that for 1 second. You know,
That brief, by the way, I urge everyone, and I'll circulate it. I'll send it to Victor. I'll circulate it to anybody who asks. Just DM me. The brief that was submitted in the Massachusetts Robin Hood case, of the 16 or so Kalshi cases, Robin Hood cases pending, that brief was the most effective advocacy that I've seen in any of these cases on either side. Not a wasted word, not a wasted paragraph. The sequencing, the transitioning, it was perfect. And I think it's going to carry the day in Massachusetts. along with, I think, what are very strong Massachusetts Attorney General briefs that were filed in the Robin Hood case. That's the swing state to watch. On November 12th, the Massachusetts Federal Court, I believe, is going to be hearing a motion to remand that was filed by the Commonwealth to get the case brought back into state court. I think the Commonwealth prevails on that motion. And if they do prevail, then the state court is going to hear in rapid fire succession the state's emergency motion for a preliminary injunction to basically force Kalshi out of Massachusetts. Were that to happen, that's going to change the complexion of all of these cases.
Right.
So the tribes case in San Francisco tomorrow, and the Massachusetts oral argument on November 12th, and the Nevada oral argument on November 14th, when Nevada is seeking to have the injunction granted to Kalshi dissolved based on the Maryland decision and the crypto.com ruling. These three oral arguments that are taking place between now and November 14th, I believe are going to set the course and basically set the table for the rest of the litigation. And unless the Supreme Court reverses it, I think this is going to go mainly the state's way, and it's going to change the complexion of everything. But we need more states in the battleground here, and not just 5 states and 4 tribes or 5 tribes. We need much more engagement, more litigation, testing the limits of this preemption argument in other federal circuit courts, and prevail in the courts. And then you have to fight off the prospect of Congress, overriding or abrogating the court decisions. But one battle at a time, but you have to keep your eye on both. And we need much more engagement from the states now instead of waiting, because if Massachusetts can force Kalshi out of its borders by the end of the first quarter 2026, which is possible, if the case gets remanded, Massachusetts wins the PI motion, and Kalshi loses an emergency stay request, they're going to geofence in Massachusetts before the end of the first quarter. And if they're geofencing in one state or around several Indian tribal reservations, that undercuts their legal argument in every other state case, because their irreparable harm is tied to the fact that we can't geofence. It's too expensive for us. And if they're forced to do it because of some court cases that are now pending, it will weaken their argument in every other case, which is why we need more states and more tribes involved. You can win this, but it requires, all hands on deck and not being apathetic about it.
Right.
Well, Jason, it sounds like we have our job cut out for us.
I know we talk it to death, and we're going to have to keep talking it to death some more. Like you said, apathy is our enemy, because, and I got to tell you, Daniel, I feel like we should just at some point just start to read off the ridiculous bets. There's one that made me think of you, Victor. There's a bet on Kalshi right now. What will happen sooner, the California high-speed rail or a man on Mars? So, I mean,
Mars.
Ridiculous stuff like that, Daniel. I don't understand how that helps their case.
That's the magic of self-certification. With states and state-regulated sports betting, you got to ask for permission to launch these sort of esoteric bets. In the CFTC, there are no guardrails. There's no permission. You just say, hey, I'm doing it. The CFTC has taken no action against anybody on anything. And that's why you see Kalshi in China and France, parlays and props. They can put up anything that they want. So, I know we're coming down to the end of the hour, but the contrast between a federal regulated or lightly federally regulated system of no permission, required versus a robust state regulatory framework in which there are sport integrity safeguards, KYC, and active involvement from the state regulators. It's like night and day, and it really is insulting. And it's so, it irritates me to hear someone like Sarah, who used to champion state regulation when she was at the American Gaming Association. She was like the queen of state regulation. The federal government has no role in regulating gambling. And now she's insultingly referring to state regulators as casino regulators and mere slot machine regulators. I mean, they are using this gaslighting approach to litigating in the courts and in their public messaging. And you're on the side of the right, you're on the side of the law, but you have to fight it, because it's not going to be self-executing. You've got to bring these lawsuits. You have to hire the right outside counsel, and you have to strategize the right way, because it's not going to happen simply because you're the good guys. They are the bad guys. They are not paying any attention to the serious sport integrity or RG issues and thinking that states have no role here. This is traditionally a field that's regulated by state governments. There is a strong presumption against preemption. Keep the battles going. You're going to win them.
Right. And you know what? And on that note, according to those guys, it's not gambling. So that's to be defined, and that's where the fight is right here.
You got to check that, Jason. Look at that last comment in the chat. That's directed to you. Very interesting. I won't repeat it for the audience, but it's very, very interesting.
Right.
I would make that call.
Well, listen, Dan, thank you so much. We're at the top of the hour. Jason, thank you so much. Dan, we're going to have to come back because this conversation is nowhere finished.
Right.
You know what? We need to dig in deeper. And, you know, we wanted to talk about too big to fail, but I think we need to talk about organizing states. I think we need to talk about, you know, if we got to be the tip of the spear, then that's what we do. And you know what? We're used to that at IGO.
Right.
Wartime consiglieres are needed here. And I'd like to be part of this conversation. And I think you guys, and I'm sorry, you guys, the tribes have been the sort of the impetus behind so much of the positive movement here, just as you were in the sweepstakes. And it boggles my mind that I'm making these comments a year after I submitted a U.S. Supreme Court brief in the West Flagler case. But I am really sympathetic to the intrusion on your tribal exclusivity and sovereignty, because what do you offer? You offer casino, you offer sportsbook. This is what the prediction markets are going to be tackling next. The self-certification allows them to venture into iCasino anytime they want. And believe me, that's coming.
Daniel, you know what? After we were done with the chairman's funeral, when we were all back at the hotel after it was over and we laid our friend to rest, we were talking about the math it would take to turn prediction markets into casinos. Yeah. So that's where we were still in the hotel, haven't even got on the airplanes yet. And we were talking about how they're going to create the math that it's going to take to create a casino. And it's not that hard. Mm-hmm. So that's where this is going. It is about gambling, no matter what you call it. Yeah, binary choices, you know, but it's gambling. And, you know, again, you don't need a law book when you have a thesaurus with these guys. So, Daniel, thank you very much.
Thank you, Daniel.
We'll be back. That was so good. Jason and everyone, even Mr. Brooks, thank you for everyone.
Were you not entertained?
Yeah, were you not entertained? Thank you, guys. We'll see you soon. Bye.
Bye. Wonderful. Thank you, Jason. Thank you, Victor.
Thank you, Daniel.
It was an absolute honor. See you soon.
Excellent.
All right, brother. You'll be back.